We'll give 5 minutes allowance for the rest to join. Otherwise, let's be patient. Thank you. Good evening, team, once again. The allowance is now over, so I would just like to take this time to welcome Vema for today's session. I hope you all will enjoy today's session. Otherwise, thank you and welcome, Vema.
Thank you, Joshua, for that. Good evening, everyone. So I believe that we are all okay and geared up for the final day of our training. So we've tackled, for the past 2 days, we've tackled some things in cybersecurity best practices and artificial intelligence. So today we're going to focus on something else, that is on data protection and all the matters pertaining to uh, data protection. So I believe that in this current era of digital transformations, most of our data is being collected and processed by different individuals and different organizations. So maybe I could pose a question to us. So what do you think data privacy is? Once again, I'd love to have uh, the class, so maybe the webinar as interactive as possible, as we have done it in the past 2 days. So maybe if you can have some takers, what is privacy according to you, and why should our data be kept as private as possible? Any takers? Nicholas? Hi, Nicholas. Nicholas, we have Hope Nyambura. Okay. Yes, Nicholas. We have Nicholas and Hope.
Okay.
Okay.
Velma, are you getting me?
Yes, I can get you.
Okay. Privacy in matter of data protection is all about ensuring that you keep your data away from other people, especially like if you have a password which is protected, maybe it is encompass the use of the 2 layers or the 3 layers form, whereby you are protecting your data so that it cannot be interfered by other people or different organizations, or even we can talk about other countries from interfering with your data.
Right. Thank you for that input. Yes, Hope Nyambura.
So as for me, I think data privacy is the right for, can you hear me?
Yes, we can hear you.
Okay, so it's the right of an individual, like anyone, anywhere, to protect their personal details from falling into the wrong hands. So that's why it's important to safeguard it. And yes,
Okay,
because
thank you for
also,
that input.
yes,
Can proceed.
because we have also Sharia, the laws that are there to make sure this happens. So it's just like a control that an individual has over their information and data.
Okay, thank you for that. So it's more of, okay, maybe I can just top up something to that. Someone is complaining that they don't have the mic, so the host will take care of that. Yeah, so data is always governed by a three-tier principle, that is confidentiality, integrity, and availability. So for any data that is collected and stored in our systems, they have to adhere to the three tiers, that is confidentiality, which means that this data should not be accessible to any unauthorized persons. Then for integrity, it has it that this data should not be altered in any way. And for availability, has it that this data should be always available to its users without inconveniencing them at their point of need. Yeah, so fast forward, I believe that we've interacted, and for the past 3 days already, you know me now. So we're going to tackle something on what data protection is and what compliance is, what processes are affected by data protection law. And in Kenya right now, we have a Data Protection Act that was enacted in 2019 November. So how do we incorporate privacy in our design? And what strategies can you put in place to ensure continued compliance? Okay, so maybe I can just have an exercise for us before we start so that at least you can be in context and in liaison. So for those guys saying that they don't have a mic, maybe Joshua will help us with that. Yeah, so we have some two scenarios, some two case studies. In July 2025, we have this data subject. So a data subject is someone like me and you, whose data is being collected, processed, and etc. So we have a data subject who made a complaint to ODPC regarding the negative use of his personal data in discriminating him from accessing a job opportunity. So consequently, he sought to have access to the personal data that led to his disqualification. So his specific complaint was this company, why refused to give him the forms that contained personal data, which had been processed after he had attended an interview. So Company Y was requested to provide a response to the allegations by the ODPC, the relevant evidence, mitigation measures being adopted by them, data protection policies, outlining the complaint handling mechanism to deal with such matters and demonstration of compliance, and specifically how data subjects can exercise their rights in relation to data protection. So in turn, Company Y confirmed that they put out a public invitation to all the candidates to apply and asked for consent from successful candidates to do background checks on them. The specific background check for the complainant revealed some negative details. So that's why Company Y is purporting that to not giving them the employment rights. So it confirmed that the negative report was in the public domain. So there was no need to share details with the complainant. So maybe as someone in the data protection space, do you think Company Y is guilty or not guilty of this matter? Any takers? Do you think Company Y is guilty or not guilty? Yes, Jack.
I've just joined, so I've not gained traction. Let me take some time. All right.
Okay. So I can't see his hands. I can see Caleb as unmuted. Yes, Caleb. Hi, Caleb. Can you hear me?
Yes, I can hear you.
Okay, maybe you can just give us your views.
I've just unmuted now. Let me check. Then I'll.
Okay, so I saw some people raising up their hands, but I'm not quite sure who they are. Okay, some people don't have mics, so maybe you can just raise up your hand and the host will give you a mic. Yes, Brian. That is Brian Masharia. You can see that you've raised up your hand. Maybe you can just give us 1 minute so that at least we can ponder upon it.
You can ask again the question.
Okay, we have this case study over here. So in July 2025, someone speaking.
Yes, this is Brian.
Okay.
So I wanted to give it a try. I think they are guilty because despite the data being on the public public domain doesn't necessarily mean that you're the custodian of the data and you didn't have the consent of being able to access it. So for me, from where I stand, I tend to feel like they were guilty. First of all, because of having that data, and secondly, because they never had the consent from the parties.
Okay. Thank you for that. So I'd just like to these studies to have us into some context. And you're going to learn about some of our rights as data subjects. So you can see Sami Kamau raising up their hand.
Good evening.
Good evening.
For me, according to what I know about employment, if he could break the terms and agreements of the visa employment job, I think he could see a clause mentioning that his information is going to be used for his background check. I think that the company is not at fault.
Yeah. That's a nice one. Any other person? Maybe we can just okay, we can all come into a consensus that these guys are guilty because they infringe a number of rights to this data subject, in as much as they were offering to give him an opportunity to work with them. So they had to comply with some principles and with some rights that they did not comply to. So that's why they are purported to be guilty. Yeah, the second case we have in August 2025. So these are just, but these are not real cases, but they're just hypothetical. In August 2025, a complainant alleges that a respondent has infringed on their rights to privacy by sending them unwarranted messages and making unnecessary calls, requiring them to pay back a loan they never took. So this complainant has never subscribed to the respondent's services or products. So this company, this company admitted that they had erroneously entered their client's number in the database. So instead of keying in 123, which belonged to their client, they keyed in 132, which belonged to the complainant. So this respondent, that is the company X, indicated that they have stopped all the messages. They have stopped sending the messages to this person, and they are organizing additional training for their staff who enroll customers and will implement the aspects of phone number verification. So do you think this company X is guilty or not guilty? Or is the matter resolved by them? Jared is saying not guilty. Sammy is saying very guilty. Yes, Sammy, you can tell us why they are very guilty.
I don't think that they're allowed to just tap into anyone's contact. As I've not provided them as my guarantor, they're just calling anyone. I did not provide that information that you could call anyone while they were applying. They have to put in a guarantor. They should call a specific person, not everyone. So I think for me, they're very guilty.
Okay. Anyone of a contrary opinion? Anyone with a contrary opinion? David Oluwagu. David has just dropped off. Austin is saying ignorance is never defense, so guilty. Yason is saying very guilty. David is saying guilty unless the complainant is willing to forgive them. Alex is saying they are guilty but making the effort to correct the mistake. So most of the guys are saying that this company is guilty. So who is of the contrary opinion? Who is saying that this company is not guilty? Caleb, I can see that Caleb has raised the hand. Or who is it? Dennis Kipkoech.
Yes, good evening.
Good evening.
Good evening.
Okay. I don't have a contrary opinion though, but I also feel they're guilty. They don't have the consent to send them the messages to the person.
Okay. Dennis.
Dennis.
Or John Obiero.
Okay, thank you.
Mhm.
Are you hearing me?
Yes, we can hear you.
Okay, thank you. I think they are not that guilty because this being a transposition error where they just misplaced the numbers, and again they accepted that they made it erroneously. It was not their will to send the messages, so I think they are not that guilty because of accepting the mistake.
So like at one side you're saying that they are guilty, and at another side that you're saying that they're not guilty.
Like after accepting, I don't think now they are now guilty after accepting their mistake.
Okay, so presumably they didn't accept, so they remain to be guilty.
If they didn't accept, then they are guilty.
Okay, that's
Yes.
interesting. So anyone else with burning addition?
The
Dennis?
company is not guilty.
Yes, Elvas, yes.
I think the company is not guilty.
Mm-hmm. Why? Okay, so maybe from my own opinion, I can say that this company is not guilty because they had this issue resolved. So ideally, the ODPC before lodging a penalty to a company, they give them a grace period to redeem themselves by issuing them a notice or maybe acting upon the complainant's needs. But if the company does not do so, then a complaint is lodged against them and a penalty is issued if they are found guilty. So this company had this matter resolved because once these complainant lodge a complaint against them that they're sending him unwarranted messages, wanting him to pay back a loan that he never took. This company acknowledged that it was their mistake. They had just transposed the last two digits, and in turn, these messages went to the wrong person. So they stopped sending this person the messages and are also organizing trainings to their staff to ensure that some such kind of mistakes don't happen again. Yeah, so we are going to have an interesting session. But before then,
Excuse.
yes, please.
Thank you very much.
Yes.
From the statement,
Mhm.
it says unwarranted messages and making unnecessary calls requiring him to pay back a loan, isn't it?
Mhm.
So a practical scenario could be I'm calling you.
Mhm.
When I call you and I send messages, messages and calls are not singular, isn't it? So I'm
Mhm.
calling you, XX, please repay our loan, this amount and all this. So I don't know to what extent you can say that the company is not guilty, because
Mhm.
that therefore means that they didn't have accurate records not only of the number, but also of the name, but also of the amount. Would it be that the mistake was so gross that they could not tally the name and the number and the amount, so much so that it would be consistent to not know that the number does not tally with the name and does not tally with the loan amount. Like, I don't seem to reconcile that, how it would be considered that it was made in error, like all these details, or was it just the number, no name, no nothing? Probably that clarification would also help us understand why we would not take the company as not guilty. Thank you. You may proceed.
Okay, so ideally, this company only made an error on keying in the number to their database. So in turn, these messages could go to the wrong person, of which it wasn't intended to, whom it wasn't intended to.
Excuse me, please.
Yes, please.
No, I just want to relate this to the real world scenario with the, sorry to say, but there's our in telcos, telecommunication companies like Safaricom. You find that in some instances, you've not made any subscription, but you find you receive messages from other people. Actually, the numbers, not from Safaricom itself. When you communicate to Safaricom, telling them that you didn't make any subscription, they tell you that they will unsubscribe. Then after some few days, it does happen again. So in that kind of, if I relate it to this, in that kind of scenario, is Safaricom not guilty of doing the same? Thank you.
Okay, so ideally, in that case, I believe that Safaricom is guilty because you lodged the complaint to them and they haven't taken action against it. So ideally, for data protection, once a complaint is lodged against something, the responding company should be able to respond to the matters and see to it, because this person has a right to go and file this case to the ODPC, and action will be taken by those in charge of compliance. I hope that answers you, Caleb.
Yeah, thank you.
Okay, so to put that into context, maybe I'll just do a short video for those of us who are quite new in data protection, so that when we cover the latter concepts in this case, at least we'll be going on the same page.
The 21st century has witnessed an unprecedented explosion of data. With every click, swipe, and transaction, we generate a digital footprint. This data, encompassing our online activities, personal information, and even our physical movements, has become a valuable commodity. Businesses and governments alike seek to collect, analyze, and utilize this data for various purposes. In Kenya, the digital revolution has been particularly transformative. Mobile money platforms like M-Pesa have revolutionized financial transactions, while social media platforms have become integral to communication and information sharing. This digital surge, while bringing undeniable benefits, also raises critical concerns about data privacy. Data privacy is not merely a technical concern, it is fundamentally a human rights issue. It is about protecting our autonomy, dignity, and freedom in the digital realm. In Kenya, where digital technologies are deeply intertwined with daily life, data privacy is paramount. Unregulated data collection and use can expose individuals to various risks. These include identity theft, financial fraud, discrimination, and even threats to physical safety. In a society increasingly reliant on digital platforms, protecting our data is crucial for ensuring trust, fairness, and accountability. Recognizing the growing importance of data protection, Kenya enacted the Data Protection Act in 2019. This landmark legislation provides a comprehensive framework for regulating the processing of personal data. The Act is aligned with international best practices and aims to safeguard the privacy and fundamental rights of Kenyan citizens in the digital age. The Act establishes key principles for data processing, including fairness, transparency, purpose limitation, data minimization, accuracy, and storage limitation. It also grants individuals specific rights over their personal data, empowering them to control how their information is collected, used, and shared. At the heart of Kenya's data protection framework is the Data Protection Commissioner. This independent office plays a crucial role in overseeing the implementation and enforcement of the Data Protection Act. The Commissioner has the authority to investigate complaints, issue guidance to data controllers and processors, and impose penalties for violations of the Act. The Commissioner's role extends beyond enforcement. They also play a critical role in promoting awareness of data privacy rights and responsibilities among individuals and organizations. This includes conducting public education campaigns, developing industry guidelines, and fostering dialogue on emerging data protection issues. The Data Protection Act contains several key provisions designed to protect individuals' data rights. One of the core principles is transparency. The Act requires data controllers to provide clear and concise information to individuals about how their data is being collected, used, and shared. Another crucial aspect is the limitation on data collection. Data controllers are only permitted to collect personal data for specific, legitimate, and lawful purposes. Moreover, the data collected should be limited to what is necessary for those purposes. Individuals also have the right to access their personal data held by data controllers and to request correction of any inaccuracies. While the Data Protection Act provides a robust legal framework, implementing its provisions in Kenya's rapidly evolving digital landscape presents unique challenges. The Act aims to protect personal data and ensure privacy, but the fast-paced growth of digital technologies and services in Kenya makes this a complex task. One significant challenge is raising awareness and understanding of the Act among both data controllers and individuals. Many people are still unaware of their rights and responsibilities under the Act, which can lead to unintentional non-compliance. Many businesses, particularly small and medium-sized enterprises, may lack the resources or technical expertise to fully comply with the Act's requirements. These businesses often struggle with the costs associated with implementing necessary data protection measures, such as secure data storage and regular audits. Another challenge arises from the widespread use of mobile money platforms like M-Pesa. These platforms are integral to the daily lives of many Kenyans, facilitating transactions and financial inclusion. These platforms process vast amounts of personal financial data, raising concerns about data security and the potential for misuse. Ensuring that these platforms comply with data protection regulations is crucial to maintaining public trust. Similarly, the increasing adoption of biometric technologies, such as fingerprint scanning for SIM card registration, raises questions about the storage and protection of sensitive biometric data. The potential for data breaches and misuse of biometric information is a significant concern that needs to be addressed through stringent security measures and regular oversight. The evolving data frontier, AI, biometrics, and the Internet of Things. The rapid pace of technological advancement presents both opportunities and challenges for data protection in Kenya. Artificial intelligence, with its ability to analyze vast data sets and make predictions about individuals' behavior, raises concerns about automated decision-making and the potential for algorithmic bias. The proliferation of connected devices through the Internet of Things also generates massive amounts of data about individuals' daily lives. This data, if not properly secured, can be vulnerable to hacking and misuse. Addressing these emerging challenges requires a flexible and adaptive approach to data protection regulation. Strengthening the Shield recommendations for a more robust data protection framework. In today's digital age, protecting personal data is more critical than ever. To enhance data protection in Kenya, several recommendations can be considered. These steps are essential to ensure that individuals' personal information is safeguarded against misuse and breaches. One crucial step is to strengthen the capacity capacity of the Data Protection Commissioner's Office. This office plays a pivotal role in overseeing data protection laws and ensuring compliance across various sectors. This includes providing adequate resources, technical expertise, and enforcement powers to effectively oversee the implementation of the Act. By equipping the office with the necessary tools, we can ensure that data protection regulations are not just on paper, but are actively enforced. Another key area for improvement is raising awareness and understanding of data privacy rights and responsibilities. Many individuals and organizations are still unaware of the importance of data protection and their roles in maintaining it. This can be achieved through targeted public education campaigns, training programs for businesses, and collaboration with civil society organizations. These initiatives can help bridge the knowledge gap and empower people to take control of their personal data. Furthermore, fostering a culture of data privacy requires promoting ethical data handling practices and encouraging organizations to go beyond mere compliance and adopt privacy by design principles. This means integrating data protection into the very fabric of their operations, ensuring that privacy is considered at every stage of the data life cycle. By taking these steps, we can build a more robust and resilient data protection framework that benefits everyone. The future of data privacy in Kenya. A call for vigilance and innovation. The future of data privacy in Kenya hinges on a collective effort from policymakers, regulators, businesses, and individuals. As technology continues to evolve, so too must our approaches to data protection. This requires ongoing dialogue, collaboration, and a willingness to adapt to new challenges. Kenya has the opportunity to become a leader in data protection on the African continent by embracing innovation while upholding the fundamental right to privacy. Kenya can create a digital ecosystem that fosters trust, empowers individuals, and drives sustainable economic growth. Conclusion. Towards a future of trust and empowerment in the digital age. In an increasingly data-driven world, protecting our privacy is not just a matter of convenience. It is essential for safeguarding our fundamental rights and freedoms. As we navigate through this digital landscape, the importance of data security cannot be overstated. Every click, every interaction, and every piece of shared information holds value and potential risk. Kenya's Data Protection Act provides a strong foundation for protecting individuals' data rights, ensuring that personal information is handled with the utmost care and responsibility. This legislation is a significant step towards creating a secure digital environment, but its effective implementation requires ongoing vigilance and adaptation. The digital world is ever evolving, and so must our strategies to protect it. Continuous monitoring and updating of security measures are crucial to stay ahead of potential threats. By embracing a collaborative approach, we can pool our resources and expertise to tackle data privacy challenges more effectively. Collaboration between government, private sector, and civil society is key to building a robust data protection framework. Fostering a culture of data privacy is essential. Education and awareness campaigns can empower individuals to take control of their personal information. Understanding the value of data and the risks associated with its misuse is the first step towards a more secure digital future, and staying ahead of emerging technological trends is vital. As technology advances, so do the methods used by those who seek to exploit it. Innovation in cybersecurity must keep pace with technological developments to ensure ongoing protection. Kenya can create a digital future that is both innovative and respectful of individual rights. By prioritizing data privacy.
All right, so we believe that as Kenyans, I believe that as Kenyans we'll be able to come up with a technological ecosystem that is both respectful to individuals' data and will also be able to encourage innovation. Yeah, so that was just to put us into context for those guys who are not quite familiar with data protection, so that at least when we're discussing some things, you'll be together with us. So we have this thing called privacy. So maybe privacy in a layman's language is more of having for the kids, they have they decide what toys to go in the box, and who can play with the toys and when they can play with them. So ideally, if someone tries to take their toys and or maybe showing them to others without asking for permission from them, they can see that those toys are theirs and they should not be shown to anyone else without their permission. So ideally, it's more of keeping your special things as safe as possible and choosing what to share with whom at what particular time. So under the Data Protection Act of 2019, that was enacted in November 2019, this is deemed as a right to control personal data. So personal data is data that is referring to, or maybe is related to a specific individual called a data subject. So this privacy ensures that when this data is collected, processed, and stored and shared, it respects the autonomy, dignity, and freedom of this data subject. So it empowers us as data subjects to specific rights that are mentioned in the Data Protection Act that we'll look at in the later slides, such as the right to access data, the right to object processing, the right to request corrections, or the right to demand deletion. So I think from this you can relate to why some of the previous cases were guilty and some of them are not guilty. So this ensures the aspect of trust is built by requiring responsible data handling and by organizations and the specific data subjects, they maintain the utmost control to whatever happens to their data. So these are on the ODPC site, there are a number of cases, or maybe there are a number of verdicts. So maybe I can or they are called issues. So I just picked up on one. So we have quite a number of issues over here that you can interact with. There are different complaints that were lodged by different people. So I chose one specific, chose one random complaint. So maybe I can just show us where these complaints are always located. So under the knowledge center, you can have the determinations. Then we have a number of determinations that are here, depending on the year that they were posted on this site. So you can just pick up on any of them and read through it. But for my case today, I picked one on Samuel Kamau Aweru, who was the complainant, and Platinum Credit Limited. So that is also a case that is present on the examinations folder on the ODPC site. So in this case, Samuel Kamau Aweru alleged receiving unsolicited calls from Platinum Credit. And these calls and messages were promoting the loan products that Platinum Credit was having without seeking his consent, or maybe without having prior engagement with the company. So the ODPC investigated this case, finding that Platinum Credit had a former sales agent who unlawfully processed Kamau's personal details for commercial purposes, infringing Section 30 and 37 of the Kenya Data Protection Act of 2019 by failing to obtain explicit consent for direct marketing to their products. So the respondent, this is Platinum Credit, was held liable for this breach and ordered to pay Kamau Aweru a sum of 400,000 Kenyan shillings in compensation. And it issued also an enforcement notice and recommendation for prosecution of these companies' directors for providing a falsified information during the process of inquiry. So the directors were alleged that they didn't have that specific sales agent in their company, but upon further investigations being taken by the ODPC, they found out that these directors were trying to give some falsified information. And this person that collected this data for processing was one of their former sales agents within the company. So at your own free time, you can just go through the different cases so that at least you can get to know how these determinations are made by the ODPC. And as well, you can interact with the site because it's quite important for us. So also have another case, that is the case for Huduma number. That was in 2021 again. So a High Court, it declared the initial rollout of this Huduma number illegal in 2021 October because it went against the Data Protection Act, specifically the Section 31, which mandates that a data protection impact assessment should be done before processing any sensitive data for personal data for any digital systems. So ideally, a DPIA is always conducted to identify whether there are any risks that may accrue due to the processing of personal data for specific data subjects. So before Huduma number collected these data, they didn't conduct a DPIA assessment test to verify whether any risk might accrue due to the processing of people's personal data. So this court ordered the government to conduct the required DPIA first for the Huduma card program before any further processing of data or rolling out these cards, since the government had not performed one, despite collecting personal and biometric data for this whole period. Yeah, so we have this law in Kenya right now. It's being enacted. It's currently in place, and it borrowed so heavily from the Constitution, more so from the Bill of Rights. That is in the Act 31, Article 31 of the Kenyan Constitution, which requires that every person has a right to privacy, which includes the right to have the information relating to the company or private affairs unnecessarily required or revealed, the privacy of their communications infringed, their person, home, or property searched without a search warrant, then their positions also being seized without the permission, maybe without a warrant. So the DPA was enacted to help us in ensuring that there's a support for the provisions of privacy as stipulated by the Bill of Rights, that is the Article 31 and C and D of the Constitution. It also came in to provide a framework for establishing national authority for data protection, which is the ODPC, and also provided a framework to regulate the processing of personal data illegally without consent. And it also provided for the rights of us as data subjects. We have quite a number of rights that we need to be aware of. Then it also came in to clearly define the obligations and responsibilities of some people that we have called data controllers and data processors within the ecosystem. So we're going to know some things about them in the later slides. So in case you have a question on anything, you can just raise up your hand. Okay, so we have a number of definitions over here. The first one being a data subject. As I mentioned earlier on, data subject is someone like me and you. So the data subject is any individual whose personal data is being processed. Then we have sensitive data. We have sensitive data as data revealing personal attributes like your race, your health, and etc. Then you have personal data, that is information that identifies or can identify an individual, either me and you. And data processing, which are actions that can be taken on data from collection, processing, storage, and etc. So we have different types of a person. We have an identifiable natural person, which means a person who can be identified directly or indirectly by specific data. So by reference to an identifier such as your name, your ID number, the location data, maybe online identifiers or different factors that can relate to you, to yourself. Personal data we have, it relates to any information that has been collected from this person that can relate to themselves. And you also have this person having some sensitive data. So this data is quite private to them, it's so much private to them. And it might be data about their health status, their biometric data, their marital status, and etc. that should not be put to the general public for consumption. So this data, once it's collected, it is processed. So data processing means any operation that can be performed on personal data, such as collection, storage, retrieving, transmitting, manipulation of this data. So as you have seen in this diagram, collection means the process of gathering any personal information from different sources. Maybe it might be from fieldwork, maybe from working clients and etc. So there's also storage. This is a process of securely storing this data for future use by your company. Then you have retrieval, where we access this stored data when you need to access it. So this also takes us back to the 3-tier principle that I mentioned earlier on, the confidentiality, integrity, and availability. We also have transmitting data, which is the aspect of sending data to different locations and systems. And it also has different laws governing the transmission of data. And we also have data manipulation, which is the modification of data to meet some specific requirements that are needed by the company. Yeah, so okay, so some other definitions that we have. Okay, sorry for that. So we have this data that is collected from different sources. So ideally, we have companies can collect data directly or indirectly from data subjects. So the law, that is the Data Protection Act, recognizes some indirect data collection methods, which are maybe gotten from, maybe this data can be gotten from a public record. That is data that is contained in a public record, data that is published by the data subjects themselves, and they have deliberately made this data public. We have data subject consent, where this data subject, or maybe whether I and you have given some explicit permission to a company to use our data, maybe to collect our data. The act of incapacitation, where this subject has an incapacity, and we have a guardian or a parent appointed to and has consented, has given permission for the collection, and etc. and etc. So again, these notes will be shared with us by the organizers of the webinar. So be sure that you'll find the notes maybe by tomorrow. Yeah, so maybe you can have a reflection based on whatever we just covered. Are you able to identify the different types of personal data and some special categories of personal data that maybe you as an organization you collect? Then as well, from this data that you have maybe identified, you should include the data that is processed by your team and different third parties, and see whether your team or maybe your organization is compliant to the various rules and principles that have been outlined by the Data Protection Act of 2019. So ideally, this is something that is catching up many companies currently due to non-compliance. So non-compliance to this act has attracted many fines to different companies. Many fines and many penalties have been lodged to different companies based on the gross misconduct that they have conducted to the personal data that is relating to specific data subjects that have filed complaints with the ODPC. So once you have your free time, just go to the ODPC site on the determinations on the Knowledge Center. On the knowledge center, you can find the determinations, then try to read whatever happened. Maybe you can find that your company is doing the same thing that the other company did, and they fell in the bad hand of the law. So we have key players within data protection. The first player is a data subject. So I think by now you have known who a data subject is. So the data subject is an identified or identifiable natural person to whom the subject of personal data is being collected. We have a controller, who is a natural or legal person, or any public authority or any other body that either alone or jointly with some other bodies determines the purpose and means of processing of personal data. So we have another person who is a data controller, not a controller but a processor, who is another legal or natural person, which is tasked maybe with the controller to process personal data on behalf of this controller. And most of these agreements all need to be in writing, so that at least in case of any infringement, you can prove yourself, because in law there is a principle of anyone who alleges anything must always give a proof of the same. So we also have a data protection officer, who is an independent advocate within a corporation, who ensures proper care and use of customer information as defined by Data Protection Act. A data protection commissioner, who is currently in Kenya today, we have Madam Immaculate Kasait, who is a data protection commissioner, who is an independent, who holds the office of an independent national authority responsible for upholding data privacy rights through the enforcement and monitoring of data protection legislation and compliance of the same. Yeah, so initially I mentioned something about controllers and processors. So ideally, a controller can be a processor, but it depends with the type of data that they're handling, or maybe it depends the scope and maybe the size of the organization. So a controller is, as I mentioned earlier on, a controller is any legal or natural person or organization that defines what data to be collected, that defines why this data is to be collected, and that defines as well how this data will be processed by the processors. On the other end, a processor is any legal person, natural or legal person, or organization that processes this data on behalf of a data controller, which includes collecting this data, organizing and structuring, storing this data for adaptation or use, retrieving this data, disclosing this data to the controllers for dissemination, aligning this data, and as well extracting this data if it's no longer in use. So this office that the office that I mentioned earlier on, the office of this data protection commissioner, it has different roles that has been tasked to it. Firstly, this office is in charge of implementing this Data Protection Act, and you can for sure attest that this act is currently in play, depending on the different determinations that have been issued out since this law was enacted. So on the determinations page, you'll find a number of determinations, a number of issues that were given to the different companies and individuals who infringe some of the rights of data subjects. So also this person, or maybe this office, it maintains a register of controllers and processors. So on the site as well, if your company doesn't have these controllers and processors, there is a section for registration of these controllers and processors. So if your company is, if it's collecting any data from data subjects, so they need to have data protection officer within the company, and as well they need to have these controllers and processors registered by the ODPC. As well, this Office of the Data Protection Commissioner audits institutions before giving the determinations, depending on the data protection policies that these companies are enacting. So they as well raise awareness on data protection. I believe it was late last year when the ODPC, the Office of this Data Protection Commissioner, was having a caravan across the country, enlightening citizens on their rights. So I believe I saw one in Eldoret last year. I'm not quite sure of the time, but I'm sure that they were doing an awareness campaign to some of the citizens to know about their rights. So this office as well, it receives, investigates, and it receives and investigates complaints from different complainants. And in case a company or maybe a respondent is found guilty, this office as well imposes fines or maybe compensations depending on the extent of the infringement of the rights. Then as well, it promotes international cooperation within the global stage. Okay, so maybe you might be asking yourself, like, who does this act apply to? The first person is either a data controller or processor who is processing personal data either by making use of automated or an automated means of processing this data. And this person should be an established or resident in Kenya and processes this data within Kenya, because we have other rules that govern how this data should be processed outside Kenya as well before being transferred to the other countries. So this person, this controller processor should not be established or ordinarily resident in Kenya, but processing this personal data of data subjects within Kenya only. Okay, and maybe who's exempted from this act? So household activity, that is the processing of personal data by an individual in the course of an household activity. The national security who are processing, who are conducting processing that is necessary for the course of national security or public interest. We have the legal requirements where disclosure is required by any by any written law or by an order of the court. The aspect of journalism, literature, and art, they are also exempted to an extent, where the principles of processing data, personal data, shall not apply if this publication is of a literary or artistic material and public interest. So some of these will interact with them when we share these content, and also have the people in research, history, and statistics also being exempted to a certain extent, where if they are collecting personal data which is to be processed only for the purposes of research, they are exempted from the act. And if this data is processed in compliance with the relevant conditions. So I believe as researchers as well, we have a body that is, I think it's Rhino, which ensures that before someone partakes a research in any field, they can register with them and they will be able to identify the processing activities that are related to this data. And the researcher must give a written agreement to the organization on how they are going to conduct the processing of this data, the collection, and how they are going to use this data before they are given consent to proceed with their research activities. Yeah, so who are mandated to comply to this act? So ideally, any institution that is processing data, maybe any institution that is dealing with personal data, they're mandated to register with this ODPC. So I've just listed some but a few. I've not exhausted all of them, right from the healthcare, the property managers, the financial services providers, those guys within the education space, the insurance companies, telecoms, political, and etc. So guys who are not exempted, guys who are exempted to mandatory registration are maybe companies whose turnover is below 5 million shillings, because for ODPC, a maximum amount of fine that can be lodged to a specific company is around 5 million. So in case a company makes below 5 million, maybe we can't even load them a maximum amount of fine. So also a company which employs less than 10 people, that's a small company that is still growing. So those are exempted from mandatory registration with the ODPC. But companies which are having a turnover of above 5 million and employs more than 10 people, they are mandated to register with the ODPC so that at least they can conduct the processing activities within the stipulations of the law. So as I mentioned earlier on, so the maximum fines for organizations which do not comply is a fixed fine of up to at most 5 million Kenyan shillings, or a turnover percentage of about of up to 1% of the organization's annual turnover. Then they'll do a calculation of a lower of the two. So an issue will be given, maybe a penalty will be imposed based on the infringement. Then for individuals, they're given a fine of up to 3 million shillings or a 10-year of imprisonment, or maybe both penalties can be imposed on someone if they did not comply to a specific law. Yeah, so in case you have a question, maybe you can just raise your hand. Okay, so I'll just cover this, then I'll give us a 5-minute break after 6:40. So we have the legal basis of processing personal data, and ideally what is covered in this law. So ideally, any person, maybe any organization to whom you give your personal data, they must have a lawful basis of processing this data. That's why they have to register with the ODPC, so that at least they can be given the different mandates of processing your data. So they must as well note the basis that is most appropriate to use the data that they are collecting from the data subjects. And they should as well state the relationship between the controller, the processors, and the different data subjects. So as well, we have any further processing that must be in accordance with the purpose of this data collection. Then we have these controllers and processors. They must ideally rely on a specific basis of lawful processing at a particular time that they are processing this data. Then this basis will rely upon a demonstrable, it must rely upon a demonstrable action at this particular point in time, because it's always an offense to process this data without having a lawful basis of processing this data. So on the Data Protection Act, which is available on the public domain, you'll find a section on the lawful processing of personal data. So you can go and read much more about it, so at least you can know the lawful basis of processing different kind of personal data as stipulated by this Kenyan Data Protection Act of 2019. Yes, Caleb.
I have a question.
Yes, please. Yes, please.
My question is, apart from maybe the charges and maybe other cautions, is there any obligation for the Data Protection Commission to protect, the citizens from these maybe websites? Let me say this recruitment website. You see, nowadays everybody is migrating to e-recruitment without a good structure, and because maybe for the public, it's hard to know who exposes your data, because if you for instance, you apply a job in 50 different websites, and you're not IT, maybe you're not good in IT, or you don't know anything, it's very hard to determine who leaked your data. So I'm just wondering, maybe if you know obligation that guides the Data Protection Commission to protect consumers or the citizens from that, please. Thank you.
Okay, I can't say that I exhaustively know the obligations, but this can be open to discussion in class as well. But some of the things that some of the obligations that this commission undertakes to protect the citizens are, they have enforced our rights. So at least we know we have a right to access to any company. We have a right to be informed by this company on how they are going to use our data. Then we have a right to object these companies from processing our data. I believe from the e-recruitment platforms, most of them have a data protection consent section on maybe when we want to apply to some of their jobs. So ideally, this is one of the things that, okay, because this consent form, maybe in case of an infringement, before a legal penalty is imposed on this company, they'll have to review all these policies that this company had in place to ensure that they are complying to the data protection basis for protecting this personal data for the data subject. As well, they perform a role in oversight supervision of these companies within the land, as they normally monitor and supervise compliance within Kenya. They also ensure that controllers within the different companies, they adopt privacy by design and by default when coming up with some of these applications. I think for now, maybe one last thing that I can mention is they also take part in safeguarding our sensitive data. Can you guys hear me?
Yes.
Okay. So they also take part in safeguarding. They also take part in safeguarding our personal data. That is,
May I please?
yes, please.
May I please add something, please?
Mm-hmm.
Yeah, as a, okay, for maybe let's take for instance you as a IT practitioner, actually cybersecurity practitioner. Do you know that these, like for instance, these recruitment agencies, there are some criminals who use job recruitments to know other companies. Like somebody poses a fake job, maybe let's say IT technician, maybe who is good in maybe AWS or what in cloud computing, just to know what that the company insights of the company that person is working. So you see, in that extreme, they just need to, maybe as a policymakers, they need to adjust, because it's hard to know such kinds of deliberate intentions of the cyber criminals.
Oh, yeah, not only do they post these jobs, but some of them as well apply to some of these jobs. Then they come up to the interviews and they shall have learned most of the things about the organization, and they'll in turn use the information to cause a breach to the organization that they were interviewing with. Yeah, so this act is still growing. We can't say that it has been fully been enacted, because there are some things that are growing day by day, and I believe that this office will take them into action as soon as possible. Okay, so maybe you can just give us a 5 minutes water break. Then we come back and continue. So we'll continue by 6:50. So you can have a 5-minute water break. Yeah, so we can resume. So we'll get straight back to some of the key terms in the legal processing of personal data. So the first key term is the aspect of consent. So daily consent means you seek explicit consent from these persons. You seek explicit permission from this data subject for the collection, storage, and processing of their data. Then as well, you need to be in a contract with this data subject. So you need to be in an agreement with this data subject for this collection and processing and etc. of their personal data. Anything revolving around their personal data. Then as well, it should be of a legitimate interest, whereby there should be an existence of an appropriate relationship between you as the company and the data subject. Then there should be legal obligations that are guiding this whole process, whereby you're required to, by law, to collect this information with relevance to the legal obligations that are guiding it as well. Then if it's for a public task, ideally it should be for the processing of this data towards national security or some similar reasons towards the public interest. Then if it's governed by the vital interest, this data is collected, where this data is collected in matters of life and death, and it's needed like as soon as possible. Okay, so we have consent being one of the key terms, which is the freely given. Okay, consent should be freely given by this data subject. It has the different features, which is it should be freely given. It should be specific. It should be informed and unambiguous agreement by this data subject to allow your organization to process their personal data. So I believe that you're going to maybe some organizations where you find some notices on the wall that once you enter these premises, you have given us a permission to take your photo and you can use it for any purpose. So I believe that that's not explicit consent. So that's a form of an implicit consent. And implicit consents are kind of tricky by the law because if any infringement happens, your organization can be found against the law in one way or another. So a valid consent, ideally, as I have mentioned, it should be freely given. This consent must be voluntary, without any coercion towards giving the consent. So this consent as well should be specific. It must be clearly defined. It must be clearly defined for a specific purpose that the data is being collected for. The consent as well should be informed, being based on a clear and understandable information by the collecting company. Then this consent as well must be unambiguous. So you can assume that these companies that have their consent forms pinned on the walls, they are quite ambiguous because they force us to give the implicit consent to the organization's cause. Maybe whatever we are going to do within the organization is so much important to us. Yeah, so we have different types of consent. The first one being the explicit consent, and the other one being the implicit consent, the implied or maybe the implicit consent. For the explicit consent, it has different features. One of them being it's a stronger form of a consent. And again, it protects the sensitive data protection because this person has given you consent without any form of duress. Then as well, it is a legally valid consent because this has come from the specific individual to the organization. Then we have implied consent, which is a weaker form of consent. It protects the less sensitive data, and it might be a potentially invalid legal consent. So ideally, what should happen within an organization if data subject withdraws their consent from your organization? So ideally, all the data processing activities that were based on consent and took place before the withdrawal of the consent by this person will still remain lawful, because by the time they are being processed, there was consent that were given to you guys to process this information by the data subject. So when this consent is withdrawn, the controller within the organization must stop all the processing actions that is concerned with the specific data subject's data. And if there is no other lawful basis justifying the processing, such as retention, this data must be deleted permanently. Then where you as a controller, you wish to continue to process these persons' data on some other lawful basis, you should not silently proceed to process this data, because it is more of infringing the data subject's right, because they had already withdrawn the consent, and you should not do this without seeking some other consent from them, or maybe without notifying them of the processing activities. Yeah, so we have different rights for us as data subjects. The first right, as I mentioned in the earlier slides, is the right to be informed by these organizations of what they specifically want to do with our data. Then you have the right to gain access to your data that is stored by these companies. As well, you have a right for rectification or the right for correction. In case you access this data, in case you access this data and you find some errors, you have the right to rectify these errors that are pertaining to your data that is stored by an organization. Then as well, you have a right to object the processing activities to your data. You have a right to, in relation to automated decision making and profiling by these different organizations. Then as well, you have a right to be forgotten. Your data has a right to, you have a right for your data to be permanently deleted by these companies. Then you have a right for data portability. In case you're moving from Kenya to some other regions, you have a right to request that your data be transferred from maybe region A to region B. But we have different rules governing this, because the other region must have some data protection measures that it is enforcing to protect your personal data. Then as well, you have a right to restrict the processing activities to your personal data by different organizations. So you have a right to object the processing and also have a right to restrict. So those are two different terms. So I can see someone asking like, how long a company should retain an employee's personal information after an employee exits the organization. So ideally, this depends on the company's policy. So maybe when this company was hiring you, you are given some policies, and in the contract they have stated how long this data is going to be held, maybe after you resigning or maybe after the termination of the contract. So some of these things are normally mentioned within the policies, and we should also make it a habit of going through such kind of documents so that at least we know whatever our companies have in place for us. Yes, so we have some other special scenarios. Okay, so if the company has a data retention policy, definitely they have highlighted maybe for how many months or maybe for how many years they're going to hold this data within their databases or maybe within their storage devices. So we have special scenarios where a third party, maybe if you're the parent to a kid who is going to a school, you can exercise someone else's rights within the following conditions. If you have a data subject who is a child, know that a child is anyone below the age of 18 years in Kenya. So where this data subject is a minor, so this person has a parent or a guardian that has the authority to process, maybe to give some rights pertaining to them. So there's an issue that was given to Nova Pioneer, which is a school, where it used a picture, maybe it used an image of a child in the marketing processes within the school. So they did not seek consent from the parent of the child. So this parent filed a complaint to the ODPC, and Nova Pioneer had to pay a penalty for the same. Then another case we have where the data subject has a mental or another disability, where this person cannot be able to give consent by their own. So a third party, maybe a person who is duly authorized to act as their parent, guardian, or administrator can give consent on their behalf. Then we can have any other person who has been given the authority by the data subject to give consent on their behalves. Yes, so we also have data protection has different principles that I mentioned. I think I mentioned some of them yesterday. We were tackling something on AI and cybersecurity on the other days. So the first principle is the aspect of lawfulness, fairness, and transparency. So ideally, all these things have been mentioned in the Data Protection Act. So in case you want to get hold of the act, just go online and search for the Kenya Data Protection Act of 2019. You'll find the whole document which contains all the things that we have covered extensively. So the first principle is the principle of lawfulness, fairness, and transparency when dealing with personal data. The second one is purpose limitation. So ideally, you as a data controller, you need to define the specific data, the specific functionality to which you are going to collect this personal data by the data subject. And you need to give them a reason. And maybe you need to state to them why you are collecting this data. Then we have the aspect of data minimization. You should only collect data that is relevant to whatever functionality that you're going to use it for. Then accuracy. This data that is collected should be as accurate, or maybe it should be on point. Then it should not contain any errors relating to the data subject. But this can be countered by maybe if you give the data subject access, they can spot the errors and you can rectify them. Then we have the aspect of storage limitation. You need to specify for how long you're going to stay with this data that is relating to the data subject. Then we have integrity and confidentiality. This data should only be accessible to the authorized persons, and it should not be altered without the approval from the data subject, because they are the bosses within this data landscape. Then the last one is accountability. You need to be accountable for any action that happens to the data subject's data. So some of the principles that we just mentioned, the principle of lawfulness, fairness, and transparency. So really you need to state what are your grounds of processing this data. So some of the an example of unlawfulness in processing personal data is when you're using consent that is not freely given or unambiguous consent, that is the implicit consent. You should use the explicit consent rather than the implicit consent. For fairness, we should ensure that we are providing the data subject to the ability to provide the free, specific, and informed choices to opt into your services. So you should not forcefully engage with the data subjects to give you the data, because there might be a data breach that is occurring and your organization will have to pay for it. So some of the examples of lack of fairness are inclusive of maybe forcing users to accept marketing as part of account opening. So as Caleb had initially mentioned, we have some of these e-recruitment sites that maybe on the bottom, if you want to sign up to their website or maybe to create an account with them, they have the marketing content automatically checked. So if you're not keen enough, you'll give an implicit consent without being keen to whatever should happen with their data. And that's why if you find maybe at one particular point you have so many marketing emails popping up to your email. Then as well, another example of lack of fairness is the organization not providing an option to opt out from the marketing. So it's more of your forcing all your products down the throats of these data subjects for their consumption, of which it's not okay within the law. Then the other one is transparency, where it necessitates the fact that you maybe have you provided your data subjects with information about what you are collecting, maybe for how long are you going to stay with them, and what you intend to do with the information. So that is the examples of lack of transparency that can happen maybe we have different terms and conditions on these used by these companies are too ambiguous or too technical for, and they're using so much jargons for normal people to relate with. Then as well, they are sharing our data with third parties without informing us. So thus infringing our rights as data subjects. Yeah, so maybe as a point of reflection from whatever we've learned. So maybe you can have a number of people contributing to this. For the first one, so maybe if someone exercised any of your rights, of their rights within your company, maybe we assume that we are all data protection officers, or maybe we are all controllers within our organizations. So we have this client who has come to exercise one of their rights. So how would you or your team go about providing a response to them? Because they have different rights that have been stipulated by the Kenya Data Protection Act. So how would you or your team go about providing a response to this? So any takers? Maybe you can raise your hands. We have a data subject that is coming into our premises. They want to exercise one of their rights. So how will you or maybe your team provide a response to this data subject based on whatever we've learned? Any takers? I can see someone has raised their hand. Dennis, keep quiet. Yes, Dennis. Dennis has dropped off. Anyone with an idea? Okay, so ideally, if data subject comes to your organization and they want to exercise any of your rights, they have a couple of rights that you should be having at your fingertips, as maybe someone who's in charge of maybe you are the controller within the company, or maybe you are the data protection and compliance officer within the company. You need to ensure that this guy or maybe this client is able to exercise all their rights to the utmost. So, and do you know how to find and access the data within the organization? So as the compliance officer as well, you need to know where this data is stored and how to access them. Ideally, you should be given the access controls by maybe the IT team to whatever is relevant for you to access. Then can you erase it, correct it, or maybe restrict it, depending on whatever the data subject wants of your organization. So you can see a second person has raised their hands. Maybe Joshua can help us with giving them the mic. We have Dennis and John Kamau. Oh, yes, John.
Can you hear me?
Yes, I can hear you.
Oh, let me give my thoughts about the first point. If the subject approaches maybe the institution, they want to exercise the right, the first thing as the team, you have to make sure that the subject is really the person who is the person, like, is really the person, not the other person impersonating him. So they have to show us maybe their ID so that we can be sure that they're the real person. Yeah, so that we can help them to, maybe if they want us to delete their database, we can go on with that. Yeah, that's my thought.
Okay, thank you for that. Yes, Dennis.
Thank you. You had not unmute me. So, for me, I'll go with first. We'll ask them how is the information that they are giving, that they are taking, how is it lawful? How do they give us consent? And maybe we know what we want to do with our data.
Okay, Catherine. I have Catherine Esther. Okay, so ideally you need to identify that the actual person that you're giving access to this data is the person whom they are claiming to be. And as well, you also need to have all these consent forms that were signed by the individual data subjects available to yourself, because in case of anything, you can be able to prove that you follow the right measures towards holding this data and maybe towards the processing activities. So ideally, these act as well. We know that we're living in a technological era and anything can happen, a breach can happen. So in case of a breach, a specific organization, it should provide some sufficient information to allow the data subject to take some protective measures against their potential consequences of this breach. And as well, these organizations must as well report this breach to the ODPC within 72 hours of the incidents. So for the data subject, they should be given a description of this nature, the nature of the breach. They should be given a description of the measures the organization intends to take to address this data breach. They should be given a recommendation on the measures to be taken by yourselves, and maybe yourselves, to mitigate the adverse effects of the breach. And as well, you're supposed to be given the contact details of this data protection officer, where applicable, or has a contact point for more information towards whatever happened to the breach and how you can contain and how you can protect yourself from whatever happened as they try to mitigate the breach as a whole. So maybe with that, in case there's a question, maybe you can just give us a room for questions for the next 3 minutes, so that at least we can call it a day and you can call it a session. So I believe that we've been able to learn a thing or two and we'll be able to implement it within our organizations. So I can see guys raising their hands, but I can't be able to know who they are. We have Beatrice Nganga. Yes, Beatrice. And David Olwang.
Hi, Vema.
Yes, Beatrice.
I wanted to ask about social impersonation and how you can deal with it.
What about social impersonation?
Like, let's say someone is taking your pictures and creating an account and is using your name and your photo to scam others and manipulate them. How can you deal with such coincidence?
Maybe the most immediate action that you can do is to report the incidents to the service providers of the social platforms that you are using.
Mm-hmm.
Maybe you can write an incident report to them with the proof of whatever is happening, so that at least they can take down the account.
Okay, thank you.
Unless anyone has any other contribution pertaining to that. We had Brian Masharia, then Joseph Kamau.
Okay, thank you, Vema. First and foremost, for taking us through this topic, data protection. My question goes to you and probably the ICTA authority. Do we have data protection courses or trainings that happens oftenly and for the purpose of certification? Secondly, so to help be able to do the checks and balances, because as you have elaborated, this tends to be a very sensitive topics, because for my end, where I work in a real estate company, you get to interact with clients, you get to interact with data on a daily basis. So whereby you're taken through on how to ensure that we are well compliant in terms of making sure that the data that you're interacting with is safe. And it's always making sure that you're also checking in line with the clients to ensure that you don't breach, you don't go past where you're supposed to go, or probably breaching the data, because I've seen different companies I've seen who have been sued because of breaching the data, or probably using other people's data without their consent. So my question goes to, probably do we have sessions where we are constantly reminded, or whereby we are taken through these sessions fully? Because yes, we have gone through the training, but it's not something that you can say that you will master it fully within this session only, whereby there's a constantly training to ensure that this thing we actualize it fully.
Okay, so for the two questions, maybe I can say that it all depends to the extent to which the organization is willing to empower its employees on data protection, because there are trainings like there are different organizations offering different trainings on data protection as well. And we also have different webinars on data protection. So you can just be on the lookout. And if you find a training on data protection that is being offered by maybe company or company B, you can give a suggestion to, maybe you can just give a proposal to your, maybe to the person in charge of your company, the operations manager, so that they can register you to attend the session, so that at least you can be at par with whatever is happening within the industry. Then for certifications, I believe there is a certification by PCB on GDPR, being a GDPR officer. So it tackles data protection from the global perspective. So as well, you can take the course, and it can enlarge your knowledge on data protection at large. Then for a free certificate, I know Strathmore and an organization called the CPIT, it offers training, a free training on data protection to individuals, a free training to individuals. So you can be on the lookout to when these sessions are being rolled out, because currently I believe that they rolled out another training, but it is sign up is already full, the cohort is already full, so you can be on the lookout to identify when they are opening up for the next cohorts. So it all depends with the extent to which organization is willing to empower the employees on data protection and ensure that compliant to every key thing that is stipulated within the Act. Who was that? I hope it was Brian. I hope that I've answered you. Yes, Caleb.
Okay. First, I'd love to appreciate your effort to educate us on cybersecurity. And then two, I just I wanted to say that in this sector of cybersecurity, it's actually we should learn that it's also there's nothing like I did say yesterday. There's nothing like absolute security. So we should be on our watch. Somebody should not tell you that something is absolutely safe. So we are not safe, and we must find a way of fighting these cyber crimes and helping those who don't know. And then two, this is a question now to you. As you know, technology is advancing. So what to tell the consumers of technology, this new technology, based on, because some people tend to consume them blindly, maybe immature. There's always a problem in challenges. So what would you advise as a cybersecurity expert? Thank you very much.
Okay, thank you for that question. So, ideally, as you have mentioned, cybersecurity is never a one-man show, and we are in the digital age, and so we need to stay vigilant. So, as consumers in this technology landscape, ideally, you need to ensure that you're protected your accounts. So, on the first day, I told us some the best practices on how you can protect our accounts by using strong passwords, ensuring that we have multi-factor authentication enabled on all our accounts, and as well you should avoid using our passwords on the across different platforms. Then, as well as the consumers of technology, we need to be wary of any suspicious messages, suspicious communications. So you should always verify before taking any action, because in case we take any action that leads to the exposure of our data, there is no way that we can go back to it. Then as well, for a basic thing, for our devices, we should ensure that they are as protected as possible. For your phones, ensure that they have passwords. For your laptops, ensure that they have passwords. We also mentioned that you should not leave our devices unattended. In case you're leaving your desk, ensure that you have locked your account so that no one will be able to access your information. So you should as well secure the use of your internet. Never access any sensitive thing on the public Wi-Fi. So I know that most of us are prone to using public Wi-Fi because they are free. So you never know if this is a digital twin, this is an evil twin that you're connecting to, and someone is listening in the network and they'll be able to get hold of the data that you are transmitting within the internet. So always backup data wherever possible so that in case you lose it, you are able to have some of it within your possession. So I think those are some of the things that I can advise the users of technology right now within this digital landscape, to stay vigilant and always ensure that they adhere to all these best practices so that at least they stay safe within the internet landscape. Yeah, so that's all from me, Caleb.
Okay, thank you very much. And just to add one, but the last on the like we did discuss yesterday about AI. You find that people tend to consume AI like yeah, let me use this word kind of blindly. You see, these things are like AI. For those who don't know, they're trained on the data we feed them. So, like, it's very hard to erase data that you feed the AI that we need. So they might affect us in the long run. So we should also be cautious on the consumption of AI. It's a good thing, I don't dispute, but we should be cautious on the real data that we give them on ourselves. Thank you very much.
All right, thank you for that addition. So we'll go to John Muigai. You can see we can have John, then Gatdwell. Okay, John has muted again. Maybe Gatdwell, you can go next.
Okay, thanks for this opportunity. I apologize for coming late. I just want to confirm something small based on public Wi-Fi. Is it wrong to use public Wi-Fi if you have enabled your VPN? Thank you.
So definitely, even if you've enabled your VPN, definitely you'll be transmitting some data within the public Wi-Fi. So there are different ways of capturing data traffic that is being transmitted within the network. And maybe this is not an encrypted communication, so someone can be able to intercept your data that you are transmitting within this network. So if you can be able to avoid using the public network, so maybe you can just avoid using it and use your own data bundles, unless you're sure that this network is as secure as possible for your consumption.
Hello. Yes. Hello.
Hello.
Yes.
Yes, you can
So
hear
it is unsafe to use public Wi-Fi.
Yeah, it's unsafe to use public Wi-Fi because you're not sure of who's listening in within the network. So You can just refrain from using it unless you are sure that it's secure.
Vema, my hand has been up for so long.
Yes, Joseph.
With my question,
Mhm.
I've not finished. Let him finish first. So is there any certification after the session of today?
That will be communicated with the organizers, so I believe it will be taken care of.
Okay. So what are the notes that we since the starting of the session up to now? So will we get the so that some of us we didn't even get into session 146 due to maybe difficulties of network. So how will you get the notes?
Everything will be shared via
Maybe
email.
for references.
Yeah, so everything will be shared by the organizers via email, so you can just expect it maybe as soon as possible.
Okay. Through the personal email.
Yeah, through the email that you registered for the webinar with.
Yeah.
Through the email that you used to
Okay.
register for the webinar.
Thank you. Thank you.
Okay.
Thank you.
Right.
Vema, can I speak now?
Yes, yes, or maybe you can kindly mute yourselves. Yes, Joseph.
Now, my question is on the first case study we did.
Mhm.
I have a lot of conflicting issues,
Mhm.
and I understand maybe I haven't followed up on the case, but I understand maybe it was a little bit of a litigation process hapo kwa sababu
Mhm.
first, when we speak of consent, does it have to be written or a verbal consent can be considered as a consent? Number two,
Okay. Mhm.
yes, yes, yes.
Okay, if you have a verbal consent, in case of a breach, you can't be able to prove that this person gave you consent towards the same. Unless you
If there
have
is a
any,
recording,
if you have a recording, you need to justify whether this is the actual person or maybe you're just using a deep fake.
no. You remember as I said, my question is based on the first case study we did on the interview and stuff. If you can remember that case study. So of course, an organization, and that is also another question. One of the questions I wanted to ask: when you are in an interview and an organization asks you, because most of the organization they will ask you, will you allow us to ask your previous employers for information about you? And the interviewee at that time, because they need the job, they will always say yes. So is this considered unfairness? Because considering that this interviewee is under pressure because they need this job.
Okay, maybe we might assume that these consent might be given under duress. So we learned about the two types of consent. We have the explicit and the implicit.
Yes.
So you can assume that this is more of an implicit type of consent because this person has no otherwise than to give the interviewer the right to maybe contact their previous employer to gauge of their personal conduct or etc.
Yes. So yes, you have answered that question. And the other thing, if I look at that study, I don't seem to see there might be no personal or sensitive information that was, let's say, for example, if I say this person didn't work, maybe lacks integrity at work, that is not personal or sensitive information. Is that considered an offense under the Data Protection Act?
So maybe if I can just make reference to that case study, we learned about the different rights of data subjects. So it's purported that this company Y, did not give the interviewee the right to access the data that they have. maybe the feedback that they were given by, maybe from the public information that they got about the misconduct of this person. So on such basis, can maybe it all depends on the rulings made by the ODPC, but the cases that we're just using today were kind of fictional. But in case of any other things, we can go back to the determinations made by the ODPC so that at least you can have a proper understanding of how these verdicts are made, because everything is included on those determinations that have been posted online for our consumption.
Noted. Thank you.
All right, thank you. So I'm seeing that you are already past time, but we have several hands. Yes, Melabon, I'm seeing that you're already unmuted. I won't be able to handle all the requests maybe for today, but you can connect maybe on LinkedIn later on, maybe on email, so that at least you can have conversations beyond this.
Okay, I have a question.
Mm-hmm.
I want to ask, how can you know, or how can you protect the data? If someone has the data, he wants to hack or he wants to do something ABCD, how can you protect it?
Okay, maybe if I can just have an understanding of your question, maybe someone has access to your data and maybe they have hacked you and gained access to your data. So the only thing, maybe you could have taken some precautionary measures before this person was able to hack into your account and get your data. So it all boils down back to the best practices of ensuring data security. As we said, cybersecurity is not a one-man show. It all boils down, it all starts from you as an individual to the organization that is having your data. If you protect your data from the lowest level, definitely it will widen the scope up to the highest level of the organizations. So for you to protect your data, ideally you need to have passwords. You have to ensure a proper cyber hygiene is implemented by yourself, so that at least these guys are not able to hack you or maybe gain access to your data.
Okay, thank you.
Yeah, so maybe on LinkedIn, you can just find me at Vemol Watch. You can just search for Vemol Watch on LinkedIn, and you can connect and have conversations beyond this. So maybe you can just allow me, for those guys who are not able to talk, maybe you can just allow me have this as the parting shot. So the cybersecurity world, we have attacks being sophisticated like every other day. So you all need to be so much vigilant, and you all need to be so much proactive and reactive as well, so that at least you can ensure that we have a cyber safe Kenya, maybe country, and a cyber safe world. So to ensure that we are all safe online. So apologies to those guys who are not able to talk. So I believe that we'll link up in the other platform so that at least you can have other conversations around this. So allow me take it back to Joshua, who will give us the further directives. So thank you once again for being a wonderful audience during the 3 days of training, and I hope that you've learned something. And thank you. Back to you, Joshua.
Okay, good evening, team. I would like to also join Vema in thanking you for your good actions during this time that we are in training, and I wish, or I hope that majority of you have learned a lot and are going to practice this in our endeavors or in our job places or even on our personal engagement. So concerning the certificates that majority are asking, these certificates will be available next week. We'll begin processing them tomorrow. So be sure that you'll be receiving your certificates via the email that you used to register for the webinar. So don't be stressed. Next week, they'll be available in your emails. And also the notes can also, you will also be able to get the notes via email. So let's just be patient and also keep the faith that we had in this webinar that you are having. So I'd also like to thank Vema for your good teachings that you've given the people. And I think majority have learned a lot and have also gained what they were not aware of in the past. So thank you, Vema, for the opportunity that you gave the team. Even to those who are unable to speak, I can see some are raising their hands and were not able to unmute and speak. So I think just as Vema said, you can connect with her via LinkedIn. I think that's only the best option that you can do. Otherwise, I wish you people all a good night and success even as you'll be beginning practicing what you've learned. Thank you and have a good night.
Thank you.
Thank you. Thank you.
Thank you.
Thank you.
Thank you.